been in the profession about 38 years, and it's been a very enjoyable time as well. Lots of things have changed, you know, the new Trademarks Act in the 90s, and Euro 2000 in the 2000 has been a very active time, you know. We went from a paper system to it's all electronic and digital now, so it's change. Then we're in the intellectual property business. That's what you'd expect. Well, I did. I really did a lot of nuclear engineering, and I didn't really want to get involved in on bench work and you know weapons and reactors. And I quite enjoy having an argument. So the patent profession around the scientific world is quite. It allows me to have an argument without getting punched in the face. Helping people to fulfil their potential in the inventions they've got, their trademarks, their designs, that sort of thing. You know, it puts them on it puts them on a level playing field with big companies. They can sue each other and enforce their rights. So protecting them is what I'm about, really. Always talk to an expert to make sure you get protection, because particularly with patents, novelty, if you destroy your own novelty, you're not going to get a patent. It's a waste of time. And on top of that, always remember the patent is the first stage. There's a lot of work involved in getting something through to commercial success, and hopefully we can help you along the way. But protecting yourself and that investment is what the patent system, the trademark system, is all about. The latest introduction of the Unified Patent and Unified Patents Court it's something that's been around for my full 38 years, and the people, hopefully it will come into play in the next year or so. But it has its advantages and its disadvantages. To develop a relationship with their clients, so that they're not worried about every time they pick up the phone they'll be charged for it, on the basis that you'll get some sort of understanding of where they're heading commercially, and also they have a background of their current IP, so that you can ensure that they're fully protected for what they've got, and value for money, obviously, because you can protect anything. But you want to make sure it's that the invention is at a stage where it's worthwhile in investing the money, basically, at the time. Well, nowadays it's all about looking at the internet and postings, and also there's a journal, SEPA journal, and a trademark journal, and just basically keeping your nose to the ground and developments, really. The patent officers will quote cases at you, and you have to obviously read them to sort of fully understand where they're coming from sometimes, and so that's how I do it. And obviously there are some cases that are famous. They come into the general media on the TV, so you read around that, so you can discuss them with your clients and colleagues. Well, that's, you know, I mean, 38 years here, but also on top of that, there are a few cases every now and again you think that's a great idea, and they tend to be the littler inventions, if I've got to be honest, the widgets and that sort of thing, and therefore when they come through, they give you a buzz, sort of thing. It's very 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 important at times. Otherwise, it's a process. The most challenging thing is basically, obviously, the cases. You know, sometimes the cases are marginal, so you're having to sort of fight with the examiner and argue about where the things are novel, where they're inventive, and also in the context of making sure that it's a commercially viable patent, because obviously you can get a patent in most cases for a client, but if it's not worth the paper it's written on, or doesn't protect that much, then they're not getting their value for money, are they? That's the main thing, you know.